Legal analysis on this case now with practicing attorney Modidima Mannya. A very good evening to you, sir. Grateful for your time. So a pre-trial conference is what now needs to happen between the state and the various defense teams in this trial. Let's talk about what that is likely to entail, given that the details of the case remain the same.
Yes, good evening, and good evening to your viewers. Look, a pre-trial process is a preparatory process. Sort out all the logistics, make sure that we have all the documents that we need, make sure that we know who the witnesses are going to be, make sure that the charge sheet is in order so that when the trial starts, it starts in earnest. Then you don't have a postponement because we didn't get this document or that document. You'll recall that in the previous trial, there were just a lot of skirmishes around this document or that document or this witness or that witness. So the pre-trial is meant to iron out those things before the trial commences in earnest.
And should these issues not have been ironed out before today? Because there was very much an indication just a few weeks ago that, in fact, this case would be restarting with a new judge, and the teams were familiar with what was required of them.
Yes, look, they will have to find each other. Otherwise, the judge will make orders with regard to the conduct of the proceedings. So it doesn't help you to disagree on things that you shouldn't disagree on. Of course, if there are material issues of disagreement, they will have to take that to the judge to make a decision.
And how much, Mr. Mannya, of an opportunity does this present to revisit issues that may have been dealt with differently in the first run of this trial? Among them, of course, I'm thinking of Zandile Khumalo's request that her testimony not be broadcast at all. Ultimately, Judge Maumela then said, in fact, all we'll have access to is audio of what she's saying. I'm thinking of the issue of the second docket, because some of the defense teams still believe that the men on trial are not Senzo Meyiwa's killers, and in fact that the second docket is what presents more of an accurate picture of what's likely to have happened in that home in 2014.
Well, look, if you watched what transpired today, Judge Mokgoatlheng is now in charge of the trial. He's got to start from scratch, from the procedural rights of the accused. He needs to make sure that everybody is represented. He needs to make sure that the court is ready to hear the matter. That's why he directed that they go on pre-trial. He's going to have to make his own decisions about whether he wants the trial to be cast in the first place. He may, in his discretion, think that it's not a wise move. He may impose more harsher conditions than Judge Maumela. He may be more relaxed. So everything starts afresh, and the new decisions will be taken almost on everything.
And when it comes to the witnesses, a lot of time has passed now, a year, I think, since this trial began last year. Many others have come to the court. A lot has been said in the media about evidence as led in this court. Is there a risk, I wonder, in terms of what the witnesses are likely to bring forward? Can they change their stories? Can they be influenced by what we've seen unfold since their appearances?
Yes, look, of course, the fact of the matter is that, witnesses have been in the witness stand. They have tasted what they've tasted. They have had moments to reflect. Well, the other fact of the matter is that that evidence is now effectively doesn't exist. So if you see Sergeant Musia in court is a new witness completely, whatever he says now, you cannot necessarily hold it against him as opposed to what he said before. So everything stands to be new. There is a risk that you may assume that because he answered this way, that time he will answer this way. So it doesn't necessarily work that way. You basically have to deal with this matter as new and forget about what transpired if you want to be safe.
And it's an interesting dynamic, of course, because this is a televised trial. So if there were to be inconsistencies or, quote-unquote, reflection on the part of the witnesses who've already come before the High Court, the public would also have a great deal to say. And I wonder to what extent that may in future influence the judge's appetite, perhaps, for the presence of the media during proceedings.
Tembek, I think we need a responsible society. When the court allows the broadcast of the trial, it is not inviting the public to participate in the trial. it is inviting the public to be aware of what is happening, to be educated. Similarly, when the court allows the media to broadcast, it's not making the media part of the trial, but it's allowing the media to play its role in society. And all these things requires responsible citizenship from all of us. Now, I do understand that people have an interest in the matter, and people will always have a view one way or the other. But of course, it doesn't in any way affect the thinking of the judge. Judges don't even bother about what you say about them in the street. They are bothered about the argument that is in court. But suffice to indicate that it's important that the trial is broadcast. It's in the public interest. But I think it calls for restraint and responsibility on both part of the media and the public, who are supposed to be the beneficiaries.
Practicing attorney Modidima Mannya, good to speak to you as always, sir. Thank you for your time.